I'm Alara Vane, 32, female, a corporate lawyer, and my life had always been about structure and control. I lived in a sleek, if small, downtown condo alone, my workspace and sanctuary, a necessary counterbalance to the high-stakes world of mergers and acquisitions where I spent my days. Everything in my world was measurable, predictable, and governed by written contracts. Or so I thought, until the predictable structure of my family life imploded. This story isn't about me winning a case. It's about me fighting one. It's the story of how my mother and brother, the two people who should have been my cornerstones, tried to wipe me out of my own inheritance, and how I used the very tools they underestimated. My profession, my focus, and my icy determination to make them regret every smirk they ever gave me. Before this story unfolds, I'd love to connect with you. Please let me know in the comments where you're watching from, and what time it is in your corner of the world. It's amazing to see how far these stories can travel. The air in the solicitor's office was thick, not with emotion, but with the cold, sterile anticipation of money changing hands. My father, a brilliant and notoriously private man, had passed away 3 weeks prior. He'd built a considerable empire from scratch, mostly in specialized commercial real estate. My mother, Vivian Vane, 60, a retired broker, sat across from me, her perfect silver hair and diamond studs, radiating an almost aggressive confidence. Next to her was my younger brother, Tristan, 30, a trust fund manager, who fidgeted with the cuff of his custom suit. They ignored me. They had for years. Tristan, the golden boy who was given a cushy job, managing the family's existing wealth, instead of having to forge his own path. And Vivian, the matriarch who had always seen me, the lawyer, as too independent, and too sharp. Qualities she valued only in men. The solicitor, a dry man named Mr. Finch, cleared his throat and began reading the will. The first few clauses were standard personal effects, minor charitable donations, and the establishment of a memorial fund. Then, we got to the real estate holdings, the core of the Vane estate. To my son, Tristan Vane, Mr. Finch read in a monotone. I leave the entirety of my commercial real estate portfolio, Vane Properties Inc., and the controlling interest in all subsidiaries, subject to the conditions laid out in Section 4, Clause C. Tristan shot a triumphant, smug look at Vivian, who returned it with a satisfied, almost beatific smile. It was precisely what they expected. I felt a familiar, cold weight settle in my chest, but I said nothing. I was waiting. I was a lawyer. I knew wills always had a residue clause, at minimum. Mr. Finch continued, to my wife, Vivian Vane. I leave the primary residence, and all other liquid assets and investments not tied directly to Vane Properties Inc.'s. Vivian beamed, reaching out to pat Tristan's hand. She mouthed, told you so. I finally spoke, my voice low and steady. And the residual estate, Mr. Finch, or any specific bequest to myself. Mr. Finch glanced down at the papers, a flicker of what might have been sympathy crossing his face. Yes, Ms. Vane. The will is comprehensive. In Section 3, Clause B, your father stated, to my daughter, Alara Vane, I leave a single sum of $50,000 to be paid out of the estate's general fund, as a token of my appreciation for her independent spirit. $50,000. That was less than I made in 2 months. It was a humiliating, insulting pittance compared to the millions gifted to my brother. The silence that followed was broken by Vivian's barely suppressed laughter. Well, darling, she cooed, her voice dripping with false concern. At least it's enough for a nice, long holiday. You've earned it, being such a busy little bee. Tristan didn't even bother with false sympathy. He just leaned back, crossing his arms, a look of profound boredom on his face, as if my very existence was a tedious formality he was waiting to dispense with. My father had always been fair, strict, demanding, but meticulously fair. This wasn't just unfair. It felt like a deliberate and cruel betrayal, orchestrated by the two people in the room, who stood to gain the most from my father's assets. I didn't believe for a second that my father, a man who documented everything, would so clearly and carelessly dismiss his own daughter, especially when I was the only one who actually understood the complex workings of his business. I stood up slowly, not breaking eye contact with my mother's mocking smile. Thank you, Mr. Finch, I said, my voice dangerously calm. I require a complete, certified copy of this will, and all accompanying schedules immediately. I also want a copy of the estate's corporate documents, including the articles of incorporation and any shareholder agreements. Vivian laughed outright this time. What, Ilara? Are you going to sue your own family for pocket change? You're a corporate lawyer, not a probate one, darling. Don't waste your precious time. I won't be suing for pocket change, mother. I corrected her, picking up my briefcase. I'll be suing for everything. My father didn't just write a will, he wrote contracts. And in the world of contracts, there are always loopholes. There are always ways to void the agreement. I walked out, the sound of their confident, dismissive laughter echoing behind me. But their certainty was my starting pistol. They thought I had lost. They were about to learn what it meant to go up against a Vane who knew the law. The certified copies of the will, the trust documents, and my father's corporate portfolio arrived at my office the next morning. I cleared my calendar, ordered copious amounts of black coffee, and began dissecting the documents. My specialty was corporate law, not probate, but the law is the law. A puzzle to be solved, regardless of the sector. Tristan and Vivian's defense was that I didn't know how to navigate a will dispute. My counter-attack was that they didn't know how to protect an inherited corporation from a lawyer who understood it inside and out. I went straight past the probate filings and deep into the Vane Properties Inc., a VPI articles of incorporation and shareholder agreements. My father, bless his meticulous soul, had built VPI like a fortress. Tristan, the nominal trust fund manager, only cared about the quarterly returns and the annual bonus. He'd never read the foundational documents. I was certain of it. His profession was a title, not an expertise. Mine was both. I focused on the transfer of controlling interest to Tristan. The will simply stated the transfer was subject to the conditions laid out in Section 4, Clause C. I flipped back to that section. Clause A and B dealt with taxes and liabilities. Clause C was surprisingly brief, almost an afterthought. Section 4, Clause CA. The principal heir of Vane Properties Inc. must maintain continuous, executive, level employment within VPI or a direct subsidiary for a minimum of 36 consecutive months, immediately prior to the testator's death. Failure to meet this employment condition shall render the bequest void, and the controlling interest will revert to the residuary beneficiary. I leaned back in my chair, a slow, predatory smile finally cracking my composure. It was brilliant. It was perfectly, classically Dad. He didn't want a slacker running his empire. He wanted an experienced operator. Tristan had been appointed to his trust fund manager position 2 years and 2 months ago, 26 months, 10 months short. Tristan, who hadn't worked a day in his life before Dad's strong armed him into a position that required little effort, hadn't met the continuous employment condition. I pulled up his public LinkedIn profile, and there it was, a 2-year and 2-month tenure at VPI, following a brief 6-month stint volunteering overseas after college, and 3 years of finding himself. The 36-month requirement was the hidden landmine my father had planted. Knowing his son's work ethic might be suspect. The best part. The will defined the residuary beneficiary clearly. Any bequest rendered void, or any assets, not specifically distributed, shall fall to the sole benefit of my daughter, Ilara Vane, to whom I entrust the final disposition of my legacy. It wasn't $50,000. It was 50 million. It was the entire company. The lawyers who drafted the will were meticulous, but they were working off Dad's explicit instructions. They made sure the primary bequest was subject to the clause, and that the residual beneficiary was me. Vivian and Tristan had seen the massive bequest to Tristan, and immediately stopped reading, satisfied with their victory. They had missed the only clause that mattered. My next call was to Marcus Thorne, 45, senior barrister, the sharpest litigation lawyer I knew, a mentor from my early days at the firm. I explained the situation, reading Clause C verbatim. Ilara, Marcus said, a genuine laugh in his voice. Your father was a genius. He didn't disinherit you. He set up a trial by fire for Tristan, and Tristan failed the eligibility test before the clock even started. That will is watertight. That clause is a vesting requirement. The bequest to Tristan is void ab initio. He was right. Tristan never legally qualified to receive the controlling interest in the first place. The money wasn't mine through a loophole. It was mine by contractual default. I immediately put a full legal hold on all VPI transactions and drafted an emergency application to the High Court, requesting a declaration that Tristan had not met the vesting conditions for the primary bequest, and that the controlling interest in VPI should immediately pass to the residuary beneficiary. The game was on, and they didn't even know the rules. I put Marcus Thorne on retainer immediately. While I specialized in the corporate law that gave me the initial leverage, Marcus was the grizzled pit bull I needed for litigation and discovery. I didn't want to just win. I wanted to crush their defense, leaving no doubt that Tristan was a fraud. My first instruction to Marcus was simple. I want every single document proving Tristan's employment status at VPI for the last 5 years. Payroll, HR logs, travel expenses, access card swipes, and email usage logs. Tristan's title was Trust Fund Manager, a role that supposedly required him to oversee the family's investment portfolio outside of the core real estate holdings. Conveniently, this was a role that could ostensibly be done remotely, which was likely how he and Vivian intended to mask his lack of actual presence. They banked on the vague nature of the title. I was banking on the rigorous documentation required for any legitimate employee. The HR documents were the first to arrive. Tristan's file was suspiciously thin. There were his initial hiring documents, signed by my father, 3 years and 4 months before his death, just long enough to look good, but critically short of the 36 months, and routine annual reviews signed by his mother Vivian, during the 2 years she served briefly on the VPI board before stepping down. No independent oversight, a clear conflict of interest, but not proof of fraud, yet. Next came the VPI payroll records. This was the goldmine. They showed a regular salary payment to Tristan Vane. The key was the accompanying expense reports and benefits usage. Tristan's salary was paid, yes, but there was a complete absence of the paper trail consistent with an executive role. No receipts for client dinners. No plane tickets for quarterly investment meetings. No continuing education expenses, and crucially, 0 internal expense reports for office supplies or departmental budgets. I, as a lawyer working for another firm, had a deeper, more documented professional footprint than the guy supposedly managing millions for his own family's business. Then, I received the access card swipe logs for the VPI headquarters. The logs were damning. In a 6-month period, Tristan Vane's access card was used precisely 3 times. Once for a Christmas party, once for a quick meeting with my father, and once for a security update. He was billing a 6-figure salary while spending an average of half a day in the office every other month. He was a phantom. The employment was continuous on paper, but demonstrably fictitious in practice. I compiled the evidence. The time gap, his initial hiring date was 32 months before Dad's passing, not 36. That alone killed the bequest. The false continuity, the 4 months between his hiring and the required start of the 36-month window contained 0 verifiable work product. The phantom executive, the access logs, expense reports, and email archives proved he was not actively involved in executive-level employment, as mandated by the clause. I even checked the email usage. Tristan's corporate VPI email account had been used almost exclusively to forward sports news, not to communicate with portfolio managers or sign off on transactions. It was a clear-cut case of fraudulent employment intended to satisfy the letter, but not the spirit, of my father's stringent clause. It confirmed my suspicion. Dad had been trying to give Tristan a chance, but the clause was his safety net, designed to protect his legacy from exactly this kind of nepotistic sloth. I instructed Marcus to file the emergency injunction immediately, attaching the access card logs and a sworn affidavit from the VPI head of security confirming the data integrity. I wasn't just voiding a will, I was exposing a 3-year-long, high-level corporate fraud orchestrated by my own family. When those documents landed on Vivian and Tristan's defense counsel's desk, the smug smiles were going to freeze. The only way out for them now was to lie under oath, and I was counting on their arrogance to lead them into that very trap. The courtroom was going to be the stage for the final act. The time for discovery was over. The time for strategic attack had begun. I had all the ammunition. The voided employment clause, the access logs, the non-existent expense reports, but simply having evidence isn't enough to win. You need to present it in a way that forces your opponents to self-destruct. My mother and brother were still living in a bubble of entitled denial, believing their lawyers could somehow wave away a 3-year paper trail of sloth. My plan, developed with Marcus Thorne, was two-pronged. First, to apply enough financial pressure to rattle their confidence. And second, to force Tristan into the witness box, where his arrogance would be his downfall. The emergency injunction Marcus filed immediately froze all non-essential Vane Properties Inc. transactions, putting a massive, unexpected dent in the company's liquidity, and preventing Tristan from touching the vast sums he thought were already his. This wasn't about spite. It was about control. When you disrupt the flow of money, people panic, and panicked people make mistakes. Tristan's immediate reaction was a furious phone call to Marcus, demanding the lifting of the injunction, and threatening counter suits, confirming he cared only about the cash flow, not the company's integrity. That gave me my second, and most critical, line of attack: deposition and trial testimony. We crafted the indictment not just around the voided clause, but around fraudulent misrepresentation of employment, effectively framing Tristan as having committed a corporate crime to defraud the estate. This elevated the case from a simple probate dispute to a matter of corporate malfeasance, which played directly into my expertise. The core of my strategy was to get him on the stand and confront him with the evidence. Corporate lawyers are skilled at cross-examination because we deal with complex financial narratives. Tristan, the trust fund slacker, wouldn't stand a chance against a lawyer who knew every detail of the company's operations better than he did. We knew his lawyers would advise him to remain silent or to claim ignorance, blaming my father for his lax attendance. So, the indictment was meticulously structured to require his testimony. By challenging his right to even be an executive, and accusing him of collecting a salary without performing the necessary duties, we forced the court to weigh his testimony against the physical evidence. The log of 3 card swipes in 6 months. The entire case hinged on one simple question. Can you state under oath that your executive-level employment at VPI was continuous and active for the 36 months leading up to the testator's death, as required by Section 4, Clause C of the will? If he said yes, I had the undeniable paper trail proving perjury. If he said no, he forfeited the entire estate. We were not going to settle. We were going for a public, definitive victory. Marcus filed the final motion for an expedited hearing, citing the severity of the financial fraud discovered within the estate, and the court, seeing the mountain of physical evidence, agreed to a trial date within the month. The Vanes were being dragged to court, not to argue over $50,000, but to defend their attempt to steal $50 million. I was ready to deliver the legal knockout blow. This was it. Not an arbitration room, not a friendly mediation, but the High Court, where every word was recorded, and every lie was perjury. I had spent my career avoiding litigation, specializing in the quiet, precise drafting of deals. Today, I was here to blow up my own family. I walked into the courtroom, and the silence immediately felt loaded. I was wearing a charcoal suit that was all business, my posture rigid, my focus absolute. My opponent, Vivian Vane, 60, was already seated at the defense table next to Tristan and their counsel, a slick, overconfident man named Mr. Harrington. The first thing I noticed was Vivian's face. Mom smiled. It wasn't a genuine, loving smile. It was a tight, triumphant expression that barely touched her eyes. It was the kind of smile she wore when she knew she was about to close a deal, or, in this case, when she thought I was making a fool of myself. She genuinely believed I was wasting my time, that I couldn't possibly overturn my father's will, because I was just a corporate shark swimming out of my depth. Next to her, Tristan looked bored, a profound, almost theatrical boredom. He was drumming his fingers lightly on the table, glancing at the clock, seemingly annoyed that my petty legal tantrum was disrupting his afternoon. They thought I'd lost, Or more accurately, they thought I was about to be officially declared the sore loser of the family. The atmosphere was a bizarre mix of sterile, legal procedure and intensely personal venom. Judge Holloway, 58th, entered, and the room snapped to attention. Marcus Thorne and I rose to present our initial motion, the declaration that the primary bequest to Tristan was void ab initio, due to the failure of the vesting condition, the 36-month active executive employment clause. Mr. Harrington, the defense lawyer, led with a condescending opening argument. He claimed the clause was ambiguous, easily satisfied by Tristan's good faith efforts, and that my father's intent was clearly to leave the company to his son. He dismissed my evidence, the access card logs, the expense report absence, as irrelevant administrative details, arguing that corporate work doesn't always require physical presence. Tristan nodded along, that bored look fixed on his face, occasionally shooting me a patronizing glance that said, "See, Elara, you're being dramatic. My job wasn't to argue the intent, it was to argue the contract." Marcus countered brilliantly, cutting through the emotional appeal. "Your Honor," he stated, his voice ringing with authority, "the law is clear. A condition precedent in a will is a contractual requirement. Section 4, Clause C defines the condition continuous, executive, level employment. We have provided documented proof, official Vane Properties Inc., security logs and payroll records, that Mr. Vane was physically present at the VPI headquarters only 3 times in a critical 6-month period. An executive does not work 3 days in 6 months, Your Honor. That is a fraudulent designation designed to circumvent the testator's clear and unambiguous requirement for competent, active leadership. The bequest is not ambiguous. Mr. Vane's employment status is fictitious." The smirk on Vivian's face wavered for the first time, replaced by a flicker of irritation. Tristan finally stopped drumming his fingers and straightened up, his eyes narrowing as the reality of the evidence hit him. I had anticipated that they would try to keep Tristan off the stand, fearing exactly this line of questioning. But Marcus, as planned, immediately moved for a directed examination of Tristan Vane, arguing that his employment status was the central fact of the case, and only he could testify to his activities during the relevant period. Mr. Harrington fiercely objected, trying to protect his client from being cornered. Judge Holloway, after reviewing the physical evidence we'd provided, upheld our motion. The witness's work activity is central to the validity of the bequest. Mr. Vane will take the stand, the judge stated, his tone leaving no room for negotiation. Tristan's face went from bored to pure shock. They thought I'd lost. They thought they could win with legal semantics. They weren't prepared for me to put the truth, backed by documented, undeniable evidence, directly under the light of cross-examination. I watched as Tristan slowly, reluctantly, walked toward the witness box, his swagger completely gone. The game was over, but the final, public shaming was about to begin. Tristan was on the witness stand, the board, entitled shell having cracked completely, replaced by nervous sweat and darting eyes. His defense counsel, Mr. Harrington, had conducted a feeble direct examination, trying to spin Tristan's absence as strategic remote oversight. But now, Tristan was mine. I stood up, walked to the podium, and addressed him with the same cool detachment I used when grilling a hostile CEO during a due diligence review. "Mr. Vane," I began, my voice clear and utterly devoid of emotion, "let's discuss Section 4, Clause C of the will. Can you confirm that you understood the bequest of Vane Properties Inc. was contingent upon continuous, executive, level employment for 36 consecutive months prior to my father's death?" He mumbled a yes. I continued, "And that period commenced on date 36 months prior to death, and concluded on a date of father's death." He agreed, looking increasingly uncomfortable. I didn't ask about his good faith efforts. I focused on unassailable facts. "I refer your attention to Defense Exhibit A, your own HR file. You were compensated as a salaried executive during this time, correct?" "Yes. That executive compensation implies you perform the duties commensurate with your high salary and title, does it not?" His lawyer jumped up. "Objection, relevance." Judge Holloway waved it away. "The witness may answer." Tristan hesitated. I managed the portfolio from wherever I was needed. I walked toward the witness box, holding a thick binder. Let's define wherever. Mr. Vane. I now introduce claimant's Exhibit 1 as the official VPI headquarters. Access card swipe log for the 18-month period preceding the testator's death. This log records every entry and exit of every employee. Do you recognize this document? He swallowed hard. I see a lot of data. Indeed. And you see your name highlighted on every page. For the 6-month period between January and June of last year, can you read aloud the number of times your access card was used to enter the VPI headquarters? He stammered, flipping through the pages. Vivian was watching, her smile completely gone, replaced by a look of sheer terror. It appears. 3 times. 3 times in 6 months. I repeated, my tone leveling the courtroom. Vane? Can you state under oath where your executive level employment was being conducted on the other 120 plus business days in that half year? He tried to deflect. I was on the road, meeting clients. I now refer you to claimant's Exhibit 20 VPI's audited expense reports. During that same 6-month period, can you point to any receipt for air travel, hotel accommodation, client entertainment, or any other business expense that would corroborate a claim of extensive travel? Tristan frantically scanned the dozens of pages of his own, zeroed out expense reports. There must be a mistake. There is no mistake, Mr. Vane. The record is clear. You incurred 0 business expenses for VPI during that period. You received a 6-figure salary, yet you were not physically present, and you were not incurring costs associated with an executive role. Now, I ask you a direct question. When you were not physically at VPI, and not traveling for VPI, were you actively performing executive level duties as required by your father's will? He was cornered. Lying under oath would expose him to criminal charges. Admitting the truth meant losing everything. He looked desperately at his mother, who was rigid in her chair. Until Tristan stammered out the words that broke their case. I was under the impression that my role was more advisory. My father knew I wasn't in the office every day. So, you are admitting that your employment was neither continuous nor at the executive level of activity required by the clause. I pressed, ensuring the legal language was undeniable. He finally slumped, defeated. Yes. Thank you, Mr. Vane. No further questions. I turned to the judge. The silence that followed was heavy with the weight of consequence. Vivian's face was a mask of hatred, but her mouth was silent. Tristan's admission, under oath, was the legal nail in the coffin. Tristan's admission under oath. The stammered, yes, confirming his fraudulent employment, was the closing argument. Mr. Harrington didn't even bother with redirect. There was nothing left to save. The courtroom settled into a strained, agonizing silence as Judge Holloway reviewed the submitted evidence one last time. Every eye was on the bench, but my focus was entirely on my family. Mom smiled no longer. Vivian Vane was pale, rigid, and vibrating with an icy, contained fury. Brother looked bored no longer. Tristan was slumped, his face defeated. The reality of losing millions hitting him harder than any moral reprimand ever could. After what felt like an eternity, Judge Holloway finally spoke, his voice measured and authoritative. The evidence presented by the claimant, Ms. Alara Vane, is uncontroverted. The security logs, expense reports, and the witness's own sworn testimony confirm that Mr. Tristan Vane did not meet the clear and unambiguous vesting condition of continuous, executive, level employment for 36 consecutive months prior to the testator's death, as stipulated in Section 4, Clause C of the will. He looked directly at Tristan, his expression severe. The condition precedent has failed. Therefore, the primary bequest of Vane Properties, Inc., to Mr. Tristan Vane is declared null and void ab initio. Judge Holloway then turned his attention to the final disposition. Under the terms of the will, the controlling interest of Vane Properties, Inc., and all its assets, passes immediately to the residuary beneficiary, Miss Alara Vane. Judgment is entered in favor of the claimant. The gavel fell. A sharp, final sound that echoed through the stunned room. They thought I'd lost until that gavel hit the block. The look of utter disbelief on Vivian's face was the most satisfying moment of my entire career. I hadn't just won a case. I had reclaimed my legacy, proving both my professional competence and my father's quiet faith in me. As the courtroom erupted into the low buzz of procedural cleanup, Marcus slapped my shoulder, a genuine grin on his face. Cleanest takedown I've seen in years. Alara. I simply nodded, gathering my papers. There was one final piece of business. I approached the defense table, ignoring the sputtering Mr. Harrington, and addressed the two people who had tried to erase me. I want you both to understand something, I said, my voice low so only they could hear, cutting through the noise. This wasn't about the money. This was about integrity. Dad set up a test, and Tristan failed because he was lazy. You both tried to use Aaliyah, a fraudulent employment designation, to steal what wasn't yours. Vivian found her voice, a raw, furious whisper. You destroyed your family over a technicality. No, mother? I corrected her, leaning in slightly. You destroyed the family when you smiled at me, and thought I was too stupid or too weak to fight back. As for the technicality, I'm a lawyer. Technicalities are the law. I shifted my gaze to Tristan, who wouldn't meet my eyes. The money my father intended for you is gone. Your reputation is ruined. And as the new controlling owner of Vane Properties Inc., I am authorizing an immediate forensic audit of all funds, handled by the trust fund manager, during his tenure. If there are any discrepancies, I promise you, I will pursue criminal charges. Consider this your final warning. The days of coasting on the Vane name are over. I didn't wait for a response. I straightened up and walked out of the courtroom, leaving them staring at each other in shock and defeat. Outside, the world was bright and bustling. I stepped into the sunlight, a corporate lawyer now tasked with fixing a broken empire. But more importantly, a daughter who finally felt the quiet vindication of her father's trust. They thought I'd lost, but they never accounted for the fact that my revenge would be rooted in the very law they assumed I was too focused on to deploy against my own blood.